data in the cloud. To deliver this presentation for us, we have M. Georgia Gibson Henlin QC, who's an information technology and telecommunications legal specialist and commercial complex legal issues litigator with over 25 years of experience in the Caribbean region and more specifically in Jamaica. She has been a member of the Ontario Bar since 2002. She's been awarded Master of Laws degrees in Innovation Law and Policy from the University of Toronto, where she specialized in the law of e-commerce and information technology, legal issues in cyberspace, telecommunications, economics, wireless communications, digital spectrum, and internet law and governance. Let's all put our hands together to welcome Georgia as she discusses the topic of implications of keeping data in the cloud. Georgia.
I want to start by thanking Christopher for inviting me and also to congratulate him on this initiative of having this conference and presentation on topical issues. The presentation is about the application of the Data Protection Act and not so much about the Data Protection Act. So you will be hearing things about the Data Protection Act, but it is more about the application of it in a particular environment, that is the cloud. It deals with the key players in the cloud provider, the cloud customer, and the cloud user, and then throughout the presentation I will see how these different parties map towards the respective rights and obligations in the cloud. The key points in terms of an overview of the presentation then will be the data protection legislation in terms of the important aspects of it that we'll be looking at, the cloud services and deployment, and I am sure that a lot of you in here know much more about cloud services and deployment than I do, so I'm not getting into the technical side of it either. And then responsibility for personal data in the cloud and compliance considerations. So we begin by asking ourselves the question, what is protected by the data protection legislation? And we say that it is personal data and sensitive personal data. So I think it's important then for us to understand what that is. So personal data is data relating to a living individual from which he can be identified, and data and other information in the possession of or likely to come into the possession of the data controller, and it includes any expression of opinion about the individual and any indication of the intention of the data controller or any other person in respect of that individual. Sensitive personal data. Just by the name, it kind of tells you that there are stricter regulations in relation to the processing of this kind of data. You see that it is more about the membership in any trade union, genetic data, biometric data, affiliation or racial origin, sex, life, physical or mental or health condition. Against that background, we have to ask ourselves, now that we know what is being protected by the data protection legislation, then the question then becomes, who must comply with data protection legislation? And it's any person who handles personal information, personal data, or sensitive personal data. I put DPL because we know that in Jamaica we don't have a Data Protection Act as yet, but we are talking about it and there's a Data Protection Bill. The presentation is based on an examination of the Data Protection Bill and an examination of the UK 1998 Data Protection Act and the recent, or not so recent, General Data Protection Regulation in the UK. So it applies certain key restrictions on the processing of personal information. And it says processing has a very wide meaning. It includes all activities in relation to data, such as storing, organizing, retrieving, disclosing, or transmitting data. And those wonderful things, as I say, that as technology people you would know about. So we're talking about processing of data, we're talking about all of those activities that comprise processing. And you can see that something as what I would consider to be inactive, you consider data at rest as storing data, is also the processing of the personal data. So who are the key players? So you see that the first person that I identify is a data subject. And the data subject is a person whose personal data is being processed. And usually that is a consumer of services. There's a data protection officer, and I call that an independent person, usually an IT professional, who ensures that there's compliance with the data protection principles. Then the data controller is a person or authority who determines the purposes for which or the manner in which data is processed. It is the controller who is ultimately responsible for compliance with the legislation, and hence the reason that the controller would be the person who is required to register with the relevant data protection regulator when it comes into effect. And who is the data processor? The data processor who is any person other than an employee of the data controller who processes data on behalf of the data controller. So why are these things important? It is because this new legislation creates a new compliance regime which has rights, obligations, and duties. So the rights belong to the data subject. And as you can see, it is the right to access the personal data in the possession of the data controller, to prevent processing that is likely to cause damage or distress, to prevent processing for direct marketing, and to prevent automated decision making, to rectification, blocking, erasure, and destruction, compensation, and to request an assessment. This is the state of play of the Data Protection Bill, to the extent that it followed the Data Protection Act of the UK 1998. But I'm sure that you would all have heard as well about another right that has since been incorporated in the GDPR, which is the right to be forgotten. And I think that started out with the famous or infamous Google case. So now I am going to run through quickly the standards of processing. I'm running through them because I have to set the context in which we are going to be discussing the rights and duties in the cloud. So I'm going to be running through them very fast. So there are 8 standards of data processing. If you think about the standards, I said earlier that the Data Protection Act basically creates a new kind of cause of action, a new type of law which you can infringe, however you want to construe it. So you have the criminal law, which imposes criminal sanctions by creating these rights, obligations, and duties. So this is a context as well where you see that the data subject has rights, and then the question is, what are the constraints that are placed on the data controller when processing data so that they could become liable if they do not conform? So that's what we're going to be looking at quickly now. So the first standard is lawfully and fairly processing of the data, and there are some conditions which define in the statute, which defines what lawful processing, what will constitute lawful processing. There is the standard that says that personal data shall be obtained only for one or more specified and lawful purpose, and shall not be further processed in any manner incompatible with that purpose or those purposes. And the example that I like to use is when you go to your insurance company, your bank, and all you went there to do is to open an account or to pay insurance, and then suddenly you start to get text or emails marketing their products to you. But so you could see easily in that context where, and also you have to watch out for that little all-encompassing box or phrase when I get to hotels where they're telling you you have to sign below, but when you look above you see that what they really want to do is to send you marketing material. So you're being asked for your consent without even being told. So it is in this context they are saying, if I came to your hotel just to stay, then that's the only reason I came there, and I do not want your marketing material. You have the standards of processing 3 and 4. If you read the UK provisions, they will say principles, but in our, I don't know if they'll change it eventually. Sometimes I don't know why we want to be different because we're talking about the same thing. But we use standards, they say principles of data processing. So standard 3 is personal data shall be adequate, relevant, and not excessive in relation to the purpose or purposes for which they are processed. So, for example, when they will ask questions, again, if we use the bank example, all you want to do is to open an account, a regular account, just to put money in and out, but the bank will ask you for your financial statements. Like me, I tell them, no, I'm not borrowing any money from you. All I want to do is to operate a savings account, and when I'm ready to borrow, then we can deal with the financial statements. So that's how I think in principle it is going to operate. Then it says, personal data shall be accurate and where necessary kept up to date. And then standards 5 and 6. Personal data processed for any purpose or purposes shall not be kept for longer than is necessary for that purpose or purposes. And you'll see that when the Data Protection Act comes into effect, they'll be making regulations which stipulate the periods for which you should retain data. And then personal data shall be processed in accordance with the rights of data subjects under the DPA. So now we'll go to look at cloud services and cloud. Did I do that one? 7 and 8? And 7 is actually very important. 7 and 8 are important and will be standards that are actually referred to in the context of cloud computing, because it talks about the appropriate technical and organizational measures that shall be taken against unauthorized or unlawful processing of personal data and against accidental loss or destruction of or damage to personal data. And this one that a lot of people are very interested in, cross-border transfer of data, which is standard 8. It says personal data shall not be transferred to any state or territory outside of Jamaica unless that state or territory ensures an adequate level of protection for the rights and freedoms of data subjects in relation to the processing of personal data. So now we look at cloud services and cloud deployment models against that background of what in some way, the Data Protection Act says. It's a much thicker document that would make you go to sleep. I enjoy it, but you would go to sleep. And so you will see in terms of information processing the cloud and application of the data protection legislation. So the use and delivery of cloud services. You'll see the different players in the cloud. Cloud provider, cloud customer, cloud user. And the question then becomes, is data in the cloud personal information? And there are lots of discussions about that, particularly when you anonymize, pseudonymize, and encrypt the data. So we say yes, if it fits the definition that I gave you at the outset of personal or personal sensitive information. Is a cloud provider the data controller or processor? And I said, probably neither, but keep in mind the broad meaning of controlling or processing. So it's always fact specific. So a continuous assessment is required. Is it processing on behalf of the controller or is it processing for itself? Is a cloud customer a controller or processor? And usually it is the customer who will likely determine the process for which and the manner in which the data is being process. So what we say then in conclusion on this slide is that the data controller's responsibility does not change because of migration to the cloud. Once you're dealing with that kind of information, you control. Once you're processing that kind of information, you control, you can be liable. So now we'll show you are no stranger to, I made up my own way of remembering these things. So you may call them the long way, and maybe what I'm about to say is not original at all, but I call them YAS, PaaS, and SaaS. Yes, so we know it's infrastructure as a service, platform as a service, software as a service. And we know as well that even though they are shown separately, that in a sense, well, in all senses, they work together. They are interoperable because you need the infrastructure in order to get to platform, or infrastructure to get to SaaS, or SaaS to get to infrastructure, and what's the other one? Platform. So we know that, but I know I don't have to tell you that, so we're going to move on from that. Good? Yes. So the deployment models now. So we have just looked at the various models for the service, and you know now, and I think possibly you may already have known that as well, that you can have the private cloud, the hybrid cloud, community cloud, public cloud, and I've set out in each one what they are. So we can see the private cloud is used for a single organization, can be internally or externally hosted. Hybrid, composition of two or more clouds, private, community, or public, and community shared by several organizations, typically externally hosted, but can be internally hosted by one of the organizations. And public, provision for open use for the public by a particular organization who also hosts service. So now, are you a data controller? And I say it depends. And so we're going to look at it now layered over the deployment models. So we say that given the consequences, it is important to identify the controller for compliance purposes. Some controllers believe that if they're in the cloud environment, their responsibility for this data security ends, or it is left to the user, that's the data subject. A data controller who outsources its data storage or processing to any third party is still ultimately responsible to comply with the obligations of any data protection regulation. Head honcho is the controller. Comes with a lot of responsibilities. But what you will find, especially in the cloud context, is that there are no bright lines as to who is the controller. Sometimes a cloud provider can be processing as well as controlling. And so throughout, you will find that towards the end or at some point, and if I don't say it at any point, then you have to appreciate that you always have to assess and you always have to clarify who is doing what because of the responsibilities that are involved. So you will always have to consider exactly what the activity is, whether it is processing, who is doing the processing, and if it's a set of activities, the same kind of analysis. So that an entity may be the controller in relation to one processing operation, but only the processor in relation to another. So remember we just looked at the cloud deployment model, so we're going to kind of drill down a little bit. So who is the controller in the private cloud? So it is easier to identify the data controller as a customer in this environment. Remember that the customer is a person who purchases basically space from the provider. And it is a controller because it is the cloud customer and not the provider who determines the purpose for which the data is used. I'm not sure if I said that correctly or properly or for you to understand it, because even in my head it sounded a little bit confusing. What I'm saying is, in the context of a private cloud, It is not the provider, because the provider is not the person who determines the purpose for which the data is used. It is the customer who does that. So the customer in that context is the data controller, right? In the private cloud, as we said, the cloud customer is the sole user of the cloud service. The underlying hardware may be managed and maintained by the cloud provider under an outsourcing contract. Access to the cloud service may be restricted to local or wide area network. So we also looked at the community cloud, which is a group access to the same cloud. So that what it means is that there's likely more than one data controller. So in effect, what we are really saying is that look at the relationships, look again at who is doing what, and make sure that you carve out what you are doing, because non-compliance comes, as you may appreciate, with stringent sanctions. For what it's worth, and you'll see it at the end, a lot of my information on this, as I said, came from the UK practice, and so there is actually a website for the Information Commissioner, and so there's a data sharing code of practice that you can go download and implement in your organization. If you search for the data sharing code of practice, you should be able to find it. Who is the data controller in the public cloud? So we have said that the public cloud is the infrastructure, platform, or software that is managed by the cloud provider and made available to the general public. Cloud customers or end user access the cloud service is likely to be over the internet. However, simply because an organization chooses to contract for cloud computing services on the basis of the cloud provider's standard terms and conditions does not mean that the organization is no longer responsible for determining the purposes for which and the manner in which the personal data is processed. In simpler terms, very often if you are entering into an arrangement to access a cloud, like how we like to go on the internet, especially as a soft thing, and they give this long thing to read, and you just scroll down to the bottom and click, I agree. In this kind of context, it's kind of dangerous, because you need to know what is it that you are agreeing to do, where the responsibilities lie as between you and either the customer or the provider, as the case may be. So is the cloud customer the processor, or have they outsourced their obligation to the provider? So even if you click on a standard form contract, it doesn't matter what the standard form contract says. If you are the person who is actually processing the data, then you will be liable. So I can't say it often enough. It is case specific, and nothing is going to change the fact that you are a controller. So what are the data controller's responsibilities when selecting a cloud service or a service provider? So we're going to look now at some risk management issues. And I've been saying it since I started that the cloud computing is not a one-size-fits-all. It is circumstance or organization or person specific. So the compliance issues that will arise depend on the type of cloud service in question. For example, when a cloud provider has an individual user, meaning a human being as its customers, so we're talking about the provider now, that's the one who provides the infrastructure, and if we follow the general principle, generally speaking, they are not controllers, because there's between them that the cloud customer, and the cloud customer would be the controller. Well, here it is. We are dealing with an individual consumer now, and the argument is that cloud provider will likely be the controller of the personal data that is collected in relation to the customer. For example, user-related personal data, including personal data provided by the customer during sign-up. So any organization considered a move to the cloud must have a clear understanding of its needs and obligations in order to ensure that it uses an appropriate cloud provider. just run through the standards of protection, of data protection, or the principles of data protection. Let's, for the purposes of what you're reading on this slide, just remind ourselves of Standard 7. And Standard 7 basically says that appropriate technical and organizational measures must be taken against unauthorized or unlawful processing of personal data and against accidental loss or destruction. So they're saying a clear record about the categories of data to be moved to the cloud must be created. For example, whether it is data for a certain type of customer or data relating to certain types of transactions, because that is what will help you when they talk about appropriate technical and organizational measures. Is not appropriate, although yes, you will have regard to industry standards, but it's not the industry standard as a whole, as a broad principle, but it's the part of the industry standard that would be applicable to the particular transaction that you are undertaking or customer data that you are dealing with. And so you have to ask yourself these questions: whether the data should be in the cloud at all, what assurances were to be given to the customer regarding the purpose for which the data was being collected, and how does the move of the data to the cloud impact the assurance? Do you have to update or revise the assurance that you give to the customer? And if so, the cloud customer must ensure that it knows what is being collected and determine whether it is necessary to make sure that cloud users are provided with sufficient information about this. For example, through a privacy policy. Remember, the cloud user is the data subject. So here's an example that I got from the Information Commissioner's Office website in the UK. So I'm going to test you, but if you take too long to answer the question, I'm going to answer it myself. So it says, a school is considering expanding its computer facilities by converting 2 classrooms to computer rooms. Traditionally, this would require the appropriate software licenses for each computer. If it switches to cloud-based SaaS model for some software, it expects to have lower overall licensing and maintenance costs. That's why people tend to move to the cloud. That's what they focus on, cost. But we're not dealing now with the other issues. So it says, an online productivity suite would allow the students remote access to their work and other educational resources. Oops, that's the answer. I realized you would be reading so quickly. So the question then becomes, what should the customer do if the personal data, such as student assessment, attainment, or attendance data, were transferred to the cloud service? Is it that they would be adequately protected against unauthorized access if the cloud service does not have proper authentication controls? Because that's a question, you agree? You're moving student data, maybe age, their grades and so on, you're considering at this stage. So what would you move between teacher information, student information, if anything at all? You take too long to answer. So the school should only use a cloud service for student work and educational resources and retain the existing network for staff to process personal data of students. Remember, the personal data is that which would be from which you'll be able to identify the students. So you could easily see this also being relevant. I will use an obvious example, like in a lawyer's office or a doctor's office. What are you going to be moving to the cloud? So we tend to use, I won't tell you which, lest your superior knowledge cause you to open your eyes wide at me. But we use a cloud service. But just to be careful, because we don't know, we don't have to criticize yet, what we do is that it is mostly the matters that are already in court, and what is at court is public. That's what we put there now. But everything else is in the office. So let's now look. After choosing the cloud provider, given what the obligations are, given what the standards of processing are, you will find that you have to have a continuing cycle of monitoring, review, and assessment in terms of the compliance obligations. Cloud provider must inform the cloud customers of changes in the sub-processors where they are layered services. There should be a written contract to ensure that provider policies are not updated, resulting in breach of customer obligations to data subject. I come back to written contracts because I know that sometimes it's a fallacy, a waste of time to talk about written contract because they're just imposing a contract on you. But remember that I've indicated that when you get that contract, given where the buck stops, you still have to try to ensure that if they are not giving you adequate protection measures, for example, you have to ensure that you put them in. Because one of the difficulties that the UK practitioners of privacy law have been complaining about, how do you ensure, apart from what they have told you, that there are adequate technical measures in place to protect personal information? Because one of the ways of doing that would be to literally visit and audit the premises. Fancy that. They're not going to allow you to do that. So you secure yourself. Those adequate or layer on adequate protection measures in order to protect yourself and your compliance. So you have to check the cloud service providers, and you have to ensure that adequately cover the risk, and if not, you have to put in your own additional measures. Still talking about the security of the cloud provider, and still talking about Standard 7, which by way of reminder is about the appropriate technical and organizational measures that shall be taken against unauthorized or unlawful processing of personal data and against accidental loss or destruction of or damage to the personal data. An important part of selecting the right cloud provider will be an assessment of the security that the cloud provider has in place. It is important to remember that the security is not the only factor that must be considered, but it is a very important one. One most common to most, what that most persons would readily think about presumptively is the encryption. So if encryption is used as a technical measure to secure data, it is important to ensure that there is a security key and that there is a robust key management arrangement to maintain the level of protection of that the encryption can offer. And it is also important to note that the loss of an encryption key could render the data useless. This would amount to accidental destruction of personal data, which would breach that principle 7. So I think we have some very good IT persons, so that's not gonna happen. But then if it happens, so unauthorized access to data, we have been speaking about this in the context of Standard 7. So the data control and the cloud customer. So yes, it's back to what I was saying, that if it is that the provider is not giving the adequate protection to you, you have to take adequate steps, because the buck stops with you, to prevent unauthorized access to data. The cloud service should offer an authentication process, for example, username and password system. And each cloud user or data subject would have their own accounts. There should also be a system in place to create, update, suspend, and delete user accounts, and to remove access from employees when they leave the organization or reset forgotten, lost, or stolen credentials. Another data protection principle, Standard 5, is engaged in relation to this slide. So Standard 5 says, personal data processed for any purpose or purposes shall not be kept for longer than is necessary for that purpose or purposes. And we know that when data is deleted, it is rarely removed entirely from the underlying storage media unless some additional steps are taken. In addition, a cloud provider is likely to have multiple copies of the data stored in multiple locations to provide more reliable service. This may include backup tapes or other media not directly connected to the cloud. Copies of personal data stored in a cloud service may also be stored in other forms, such as index. The cloud provider must not process a customer's or the cloud user's personal data without the agreement of the cloud customer. This context as well, when it speaks about the data being deleted and that it is really removed entirely from the underlying storage, that's a context in which the right to be forgotten also comes up, because the right to erasure and deletion that is now, and blocking that is now in the Act, what it does is that is really, in a sense, limited to inaccurate information, to correcting inaccurate information. So it's only pursuant to this data retention policy that they are talking about deletion, and to strengthen it, that is a context in which there is this provision about the right to be forgotten. There should be no further processing. So this is where I had raised it at the outset when we talked about the whole context of the purpose of which the data has been collected and whether you are able to process it for another use. Because you send an email of the data from your that customer information desk where you open your account to the sales and marketing department, you're actually processing the data as well. So you have to, and also with the advertising and the text that come to your phone offering a loan that you don't ask for and all of those wonderful things. Yeah. So you have to be cognizant of that if you're working, particularly you find it in the financial services industry, where you get the marketing material or the marketing emails that you are not quite interested in receiving. Now, where's the cloud provider located? This is one of the troubling areas for most persons, especially when we heard as well that even though the Data Protection Act is not yet passed in Jamaica, we hear that the GDPR is nevertheless relevant to us if we are working with customers in the EU or the European Economic Area. And so they are saying that if the computing resources that is managed by a cloud provider may be located outside the UK, or when that time comes outside of Jamaica, and standard 8 is a critical standard, because that's the thing with the cloud. And as most of us know, I don't know that we have many data centers in Jamaica that provide a cloud service. So most of the data centers are in the United States. But it says personal data shall not be transferred to any state or territory outside Jamaica unless the state or territory ensures adequate levels of protection for the rights and freedoms of data subjects in relation to the processing of data. Remember the rights that I had read at the outset of the presentation. So that the cloud customer now should be asking the potential cloud provider for a list of countries where the data is likely to be processed and for information relating to the safeguards there. The cloud provider should also be able to explain when data will be transferred to these locations. In relation to the United States and the EU, for example, if you do business with the United States and the EU, there is what is known as the Privacy Shield, and it replaces what in the past was known as a safe harbor provisions of the data protection regulations. Why is this important? It's important because there was once a tension between the United States and the EU in terms of how they manage data. UK and the EU more stringent, they say, than the United States. So in this context, they came up with a compromise, as it were, to determine the standards on which data is to be transferred from one to the other. So that is now known as a privacy shield. And the Swiss government has entered into a separate one with the United States in 2017. This was designed by the US Department of Commerce and the European Commission and the Swiss administration to provide companies on both sides of the Atlantic with a mechanism to comply with data protection requirements when transferring data from the European Union and Switzerland to the United States in support of transatlantic commerce. Technically, in a sense, when I saw this, to the extent that we engage or use. That's basically what I read a short while ago. But to the extent that we do a lot of trade and so on with the United States, in a sense, or most of our data is backed up or located in a data center in the United States. In a sense, it would make sense after you have perused this yourself. I'm not giving legal advice from here. I'm only saying to you what would help and where you can look and inform yourselves. And so it seems to me be worth your while to sign up or self-certify in this kind of environment in order to demonstrate to your EU customers, for example, that you would have had adequate levels of protection in relation to their data. Maybe going forward, because it's quite unlikely, it seems to me, that we would be coming up with anything that is adequate for any of these persons. And also, why reinvent the wheel, in a sense? I get we can, but why? So it says here, it says, while joining the Privacy Shield is voluntary, once an eligible organization makes a public commitment to comply with the framework's requirements, the commitment will become enforceable. Notice, no, under US law. All organizations interested in self-certifying to the EU-US Privacy Framework or Swiss-US Privacy Shield Framework should review the requirements in their entirety. Can't say it better, not coming from me. Don't want to hear Gibson Henlin says. I've directed it to the source, it's on the internet. And it's a government website. To assist in that effort, the Commerce's Privacy Shield team has compiled resources and addressed frequently asked questions. Now, in addition to, I'm coming to the end. In addition to all that I have just presented to you, I know it's a mouthful. Sounds like they're trying to teach IT people law, like how they tried to teach me IT when I did my master's. Welcome. But in order to help you to navigate through this, I went through the trouble of downloading a part of the checklist that you would use in your initial assessment and your ongoing assessments. So they are being handed out as I speak. In the meantime, and when you get them, you will see that what it does, it is basically setting out a set of about 5 considerations that you should take into account once in order to determine if you are a data controller, and if you are a data controller, the measures that you should take in order to ensure that you are compliant. So you will see that you will identify the risk by making a list of the personal data and how it will be processed in the cloud. You will see where it speaks to the confidentiality. It talks about the integrity of the data, availability, and of course, legal is never left out of anything, so it is also there. And of course, the legal framework would center around the Data Protection Act. Now, as I have indicated, I could not have done this without relying on all of those wonderful pieces of research. So I've listed them at the end of my presentation. And the data sharing protocol is also there. Guidance on cloud computing is kind of like what I followed to make the presentation to you. And then there are texts, those texts, and the Privacy Shield framework, which I think will be very, very useful if you are asked or find yourself in the context of being a controller or having to migrate to the cloud. Those, well, when I'm in court, I'll say it like when I'm in court, I say, if it pleases you, my lords and ladies, those are my submissions. It's self-moderated? Oh. Any questions? Okay.
Good afternoon.
Good afternoon. And before I begin, I have 3 persons here who thought they accompanied me for moral support, but they will be available to answer your questions. They're my associates, Nicola Richards, Tawana Bennett, and Stephanie Williams. Yes. Yes, question. I can't see. There's a lot of lights.
So
yeah. Oh, okay.
my question is regarding the legislation that you say is now under scrutiny before it's made into an act. Is there anything that protects the consumer from opting in to the use of an essential service that will mine their data and store it in the cloud?
Is there anything that
protects the consumer from opting in? So just like what you spoke about earlier, when you're using an app and you don't read through the fine print to see what all the ins and outs of using the app, so you're basically giving them your data to use as they please. Is there anything? Are they considering that in their handling?
When it says the data must be processed for the specified purpose, it says that it must be lawfully processed, and then it talks about the further processing. So if I'm signing on the service that let us think about. You have to forgive me. I always can only think of clothing stores. So let us say. Let us say you're logging onto, say, Macy's website or Untitled website, and all you're going on for is to purchase a dress or a shoe or something. I think the way that the legislation is crafted, they have to put something on the screen that makes it very clear, a short thing that is right there in your face that brings it to your notice that you're signing up for more than just purchasing and for example in Canada, I know there's this anti-spam legislation, and the anti-spam legislation covers everything that is even not what we ordinarily consider as spam, because it's that provision here as well that speaks to the advertising and marketing. So you begin to get the emails from Macy's that you didn't really want and you didn't know that's what you're clicking. For example, you have to have like an unsubscribe button.
You mentioned earlier a little bit about cloud providing and how there's that data safeguarding of information when we're dealing with overseas data.
The privacy shield.
Pardon me?
Is it the privacy shield?
No. You were mentioning a slide about cloud providers. So realistically, my question is, how large of an opportunity do you see Jamaica in terms of creating cloud providers from an entrepreneurship perspective?
How large? I think it's a very big opportunity. However, and even as I was speaking, as I was preparing, I thought of it, but even with internet services now, it's going to be in terms of difficult to take up. So there is the opportunity, but in terms of take up, that's where I see the issue. So most of the data centers, as you know, are located in the United States. But there is a great space here for data centers to be set up. I think some of the IT persons here will be better able to tell you how many data centers we actually have. In my mind, I'm thinking of at least 2, but I'm not sure. But there are the opportunities, yes.
Hi, good afternoon.
Good afternoon.
How do you guide the data subject who has taken out a cloud service in a service like Azure or AWS, where the data is geo-redundant, meaning it's all over the place, all over the world? And what happens in a disaster recovery scenario when it has to fail over in Europe or in a state that doesn't really have any jurisdiction in terms of certain laws?
In Jamaica?
I'm sorry?
You're saying doesn't have any jurisdiction?
Yeah, so
I'm accessing.
I'm a failure, and I've failed over to like the Jersey Islands, which or somewhere in Panama, which has very loose laws. Or I'm not a lawyer, but those areas where the laws are not defined in terms of data protection. what changes for the data subject in terms of the data once I've lost the data and it fails over to somewhere else?
Okay, so I'll answer. It's a legal answer that I'm going to give to you, in the sense that you're talking about a question of jurisdiction, and technically which court, in a sense, will have jurisdiction in terms of the rights of the data subject. So the way that the data subject would tend to deal with it is that, did that provider or cloud customer have a substantial presence in Jamaica, marketed the product or the service to them in Jamaica, accessed in Jamaica? That gives the Jamaican court jurisdiction over the subject matter of the dispute. Because the Jamaican court has jurisdiction over the subject matter of the dispute, then it can be litigated here. After it is litigated here, then you can seek to enforce it there. Litigated here means you're going to follow through the processes of service and so on, and reciprocal enforcement if it exists, and if not, you go to the jurisdiction to enforce. But the fact that a controller or processor is located outside of Jamaica is not in principle a bar to the protection of the rights of the data subject. I hope I've answered your question. Any other question?
Just out of curiosity, in terms of the right to be forgotten, do you see any challenges in the Jamaican landscape for that?
Any challenge meaning
for the right to be forgotten. So you are signed up with a Jamaican company, and that your data is hosted in the cloud. And then your request is, look, I don't want to be a part of this, please erase my records, and it's not done. Just thinking about the challenges that we would refer to.
Well, I'm going to, because it's out of curiosity, because it's a principled question you're asking, a question in principle, our courts, as you would have seen today, are quite astute and up to date in terms of protecting fundamental rights or rights in different ways. So it is something that would have to be tested in court. When they did the right to be forgotten in the Google case, it was the first time. And people were shocked when they ruled that. Some were shocked, some were elated. Maybe Google was shocked, but consumers were elated. So every time you think about a right and whether it can be tested, you will not know what will happen until you have tested it. So you have to have the mental fortitude and decide whether you're going to hire a lawyer for something like that. So Nids, who knew that it would have been struck down today, you heard, right? Okay, yeah. So who knew? So that's an example of something that people would have thought that a chance has been taken. That is something, for example, that talks about, in a sense, the very issue that we're talking about today in terms of personal information. But for the moment, it's one to the persons who are opposing it. So you never can tell.
Hi, good afternoon.
Yeah.
Quick question. Have we identified anybody locally who would be responsible for enforcing compliance?
The statute is not yet in place. So if we use the example of, I think, the new Integrity Commission, it will be a setup similar to that. Or the Fair Trading Commission, the Financial Services Commission, an overarching regulatory body, and there's a commissioner. So that setup will also be taken into account when the act is coming into place. Okay, thank you so much.